All right, welcome back. Welcome back. Good. All right, how's everyone doing? Good. My throat is mostly back to normal. I had a bad head cold last week, but I think I'll do okay today. Is everyone feeling all right? Yeah. Okie doke, we are halfway. This is class 16. We are halfway through. Next week is spring break. We are rolling along. And hopefully everyone's enjoying it. All right. Any questions from last class? Any questions about the 14th Amendment or the Civil Rights cases or Section 5? Anything on your minds? Anything? No? Okay. So if you'll pardon me, let's go grab a cough drop for a second. So today we're going to be doing things a little bit backwards. Okay. Why is it backwards? Well, in the last class, we did the 14th Amendment. The stuff that came after the Civil War. Today, we're going to go back in time and discuss probably the most controversial and I'd say disgraceful opinion to appear in our Supreme Court reports, which is a case called Dred Scott v. Sandford. Okay? Why are we doing this case after we did the 14th Amendment? The reason why is until late into the 20th century, the Supreme Court did very little to actually roll back the effects of Dred Scott. As perverse as this may sound, even though the 14th Amendment was ratified in 1868, it took another 75 years for the promise of the 14th Amendment was actually fulfilled. So although on its face, 14th Amendment nullified Dred Scott, in practice, the results of that decision lingered well into the 20th century. So to begin, we need to understand where the decision came from. So today we're going to be doing two main decisions, Dred Scott and Plessy versus Ferguson. These are both cases which you should have heard about, but I make no assumptions anymore in law school that you have studied them. These two cases represent efforts by the Supreme Court to deal with what's often dubbed as the stain of our society and our Constitution itself, which was slavery. And the manner in which the court dealt with these were very much a product of their times. So I encourage you for today, it's really easy to jump all over these opinions based on contemporary values, saying, oh my God, these cases were so wrong. How can they say this? You're right. You're absolutely right. But for purposes of class today, I want you to understand these opinions at the time they were written. This is one thing I try to encourage you. Supreme Court decisions in books can be criticized 100 years later very easily. But think about what the decision meant in the 1850s. What Plessy meant in the 1890s, at these pivotal junctures of American history. Dred Scott, on the cusp of a civil war over slavery. Plessy versus Ferguson, following the Civil War, Reconstruction, and the rebuilding of the South. These were times when the judges of the Supreme Court were operating in a very specific setting. And what I want you to keep in your minds, and don't let this one go, had the court ruled differently, what would have happened? Had the court ruled in 1853 that freed slaves were citizens, what would the states have done? Had the court ruled in 1890 that Louisiana cannot segregate its train cars, what would Louisiana have done? And the answer to these questions, or these hypotheticals, are nearly as important as the ruling itself. Because as we've discussed on the first day and thereafter, judges by their own merit have no power to change law. I think the Plessy opinion recognized that. They have no power to change values. That they only exist within a broader scope of society. But I also want you to consider, to what extent these two decisions make the situation much, much worse. To what extent did the Dred Scott decision, which tried to alleviate the problem of slavery, actually exacerbate it and propel us in the path towards a bloody civil war? To what extent did Plessy versus Ferguson try to avoid racial tensions when in reality its decision worsened them in ways hardly imaginable in the 1880s following the 14th Amendment? Both these decisions illustrate key aspects of how courts decide these tough cases. Okay? Everyone with me so far? So don't just jump on and say, oh my God, it said inferior racist decisions, terrible. You're right. But let's actually try to break this down as a legal issue as would have been understood in the 1850s through 1890s. Okay? Any questions before we get started? This will not be a happy class. We have some happier classes. This is not going to be one of them. But I encourage you to push through it. So a little bit of history first. By the way, this is noted in the book, but the case report is Dred Scott versus Sandford with a D. It was actually Sandford. They made a mistake in the heading of the case. It was actually Dred Scott versus Sandford. So we have here this portrait, which I've seen. It hangs in the Harvard Law School library of Roger Brooks Tawney. And I think the artist really captured Tawney well. He was a tortured person. Okay? He sat in the Supreme Court after the long tenure of Chief Justice Marshall, widely regarded as the greatest Chief Justice of all time. Tawney is commonly known as perhaps the worst Chief Justice of all time. And he has this sullen look over him, as if he was disappointed, or as if he couldn't quite capture it. But something was very much bothering him. So what was bothering him? It was the case of this guy, Dred Scott. This is a very familiar picture, which I'm sure many of you have seen. By the way, we do not have a picture of Homer Plessy. None exists. You can Google them, and people say, "Oh, this is Plessy." It's not. We actually don't know what he looks like, and I've spent days looking into this. We have no known drawing or photograph of him or painting. It doesn't exist. But anyway, this is Mr. Dred Scott. Okay, this is actually the cover sheet of the decision of Dred Scott v. Sandford. There's an errant D inserted there. Okay, so let's talk a little about history. The history of slavery is really the history of the early United States. So at the time of the Constitution's ratification in 1789, there were slave states and there were free states. And we discussed that one of the prerequisites for ratification, right, one of the key factors needed to ratify the Constitution was slavery. If the northern colonies, by then the northern states, had tried to eliminate slavery in its entirety, we would have had no constitution. None. Zilch. Zero. We would have never gotten to ratification. We would probably split off into two different countries, and it's very unlikely that the nation would have ever existed. So a series of compromises were reached. But these compromises are just as important for what they said as what they did not say. Okay? The first compromise was concerning the slave trade. Okay? This was the importation of African slaves from the Caribbean, from Africa, and elsewhere. This was how new slaves were brought to the United States. The compromise was this. For 20 years, until the year 1808, the slave trade was safe. It cannot be prohibited. Okay? This was a compromise. They said, listen, we will try and get rid of this at some point, but for now, we need to leave this in place to get past the first 2 decades of our country. Another compromise was one we discussed, which was the 3/5 clause, although it's misunderstood. The 3/5 clause said that effectively, for purposes of taxation and representation, slaves are only considered 3/5 of a person. Now, people think this is terrible, what they actually don't appreciate is the Southerners want him to be a full person for representation. Why? More votes in Congress and more electoral votes. The 3/5 was actually a compromise that benefited the North, because that way the Southern states would have less clout in Congress and fewer electoral votes. But even with the 3/5, the number of slaves bolstered the population of the South. So that virtually every single president for the first 40 years of the Republic was a Southerner or a Southern sympathizer. Only exceptions were John Adams and John Quincy Adams from Massachusetts. All other presidents were either Southerners or people sympathized with the South. Another compromise was the Fugitive Slave Clause. What was the Fugitive Slave Clause? If a runaway slave, made it to the North, Harry Tubman, right? The governor of the northern state was obligated to send the slave back to the owner in the South. As much as the northern states hated it, they were bound by the Constitution under this provision. Okay? But these were only the first set of compromises concerning slavery. The next major battle over slavery occurred with the Louisiana Purchase. Okay? Now, many of you probably studied the Louisiana Purchase, but I doubt you've ever thought about it from a constitutional perspective. Okay, so this is the United States in 1789. This is how it existed at the time of the ratification. What you'll see shortly thereafter in 1800 and 1821 is a lot of new territory was added. How did we get this territory? Thomas Jefferson, as president, struck a deal with Napoleon Bonaparte, the leader of France. Did he ask for Congress's permission to acquire the Louisiana territory? No, he did not. See, this entire executive action thing has been going way back to Jefferson. This is nothing new. But under the Constitution, who has the property to acquire territory? That would be Congress. How did Jefferson, as president on his own, acquire Louisiana territories? He basically said this was so beneficial to the national interest that a, quote, strict observance of the written law is not necessary. He says this, let me read this to you. To lose our country by a scrupulous adherence to the law would be to lose the law itself. Jefferson wrote, this was so important to our country as a whole that following the law would lead to the law losing itself. I want you to think about that, because we'll come back to this with Dred Scott and Lincoln. All right? We study here, I make you carry one of these around in your pocket every day, right? But the fact of the matter is, at various points, presidents have said, screw it. The ends are too important to follow this document. And in some cases, we say, oh my God, that's terrible, it's unconstitutional. In other cases, we say, okay, that was what had to be done. That was necessary. And how you treat these deviations from the Constitution says a lot of how you value the rule of law. And I'm not telling you there's a right answer or a wrong answer. I think both sides have very strong answers. But at various junctures in history, presidents have said, the ends are so important, we cannot lose this. Lincoln said himself, what's the point of preserving the Constitution if the Union fails? If our Union was destroyed in the Civil War, what good is this piece of paper? Paper, parchment barriers, right? Anyway, so Lincoln acquired through the Louisiana Territory all these states, going all the way up around here, and including parts of Texas even, not of present-day Texas. So what happened? The southern states said, oh, wow, this new territory, awesome, make them slave states. The northern was like, uh-oh, no. We need to be free states, because the more southern states there are, the more southern voters there will be who will perpetuate slavery indefinitely. So a compromise was reached in 1820. Okay, what was this compromise? the Missouri Compromise. It said, excuse me, any state north, any new state north of this line will be a free state. For example, Maine, right? Maine had become a state. It will be free. Any state south of this line, with the exception of Missouri, would become a slave state. That's why it's called the Missouri Compromise. The idea was, let's section off the country. All the new northern states, like all these ones up here, would be free, and all the southern states would be slaves. This was a compromise made in 1820 that was a hope to balance out the country roughly in the middle and allow, or at least maybe postpone, the crisis over slavery. As it turns out, we'll discuss later, Dred Scott found that the Missouri Compromise itself was unconstitutional. But at the time, no one really made big a fuss about it. Okay? So this is where we are in 1853, where the nation is split roughly in half. You have in the north the free territories, and you have in the south the slave territories. And every single new territory was fighting over whether it would have slavery or not. The survival of our republic depended on this single question. It's very hard for me to state how significant this issue was. Okay? And that brings us back to our sullen friend, Mr. Tawney. He looks like Snape from Harry Potter. I don't know. Whenever I saw, it's like, yeah, it looks like Snape, doesn't it? Yeah. Alan Ricks, right? No, Pee Wee Herman? No. No, I don't see it. Sorry. I'll give you Snape, but not Pee Wee Herman. No. So we have here Mr. Tawney. What was his goal, right? What was his mission? He had this case before him that threatened to rip apart the country either way. What is a judge to do? Find a way to rule narrowly and resolve the issue as cleanly as you can? Or try to rule broadly and settle the slavery issue once and for all with a written opinion? Some of you are laughing, but Tawney, in his heart of hearts, thought that the correct path was to rule as broadly as possible and let the Supreme Court decide the slavery issue. This did not work out, to say the least. And that doesn't even come close to it. Tawney's effort to reach out and not only decide the question whether Dred Scott was a citizen, but to actually invalidate the Missouri Compromise and hold that Congress cannot prohibit slavery, and hold further that the elimination of slavery violates due process of law, blew up. I can't stress this enough. There's a very strong argument to be made that the reason why Abraham Lincoln was elected president several years later was because of this decision. Lincoln was a small-town lawyer in Illinois who rose to fame on speaking out against the Dred Scott decision. And then, of course, Lincoln's election led to the secession of several southern states and triggered the Civil War. So it's not to say that Dred Scott caused the Civil War, but there are several key pieces that put into motion what became the Civil War. Dred Scott was a big one, a big link in that causal chain. As a nice footnote, during the Civil War, Tawney issued a decision, a case called Ex parte Merriman. Lincoln had started locking people up without any due process or habeas corpus. Tawney, in decision, said, Lincoln, let him go. And know what Lincoln said? Make me. And again, think about, is that the right idea? Lincoln was very clear in his view that if a Supreme Court decision was, in his mind, wrong, it does not need to be followed. He spoke throughout Illinois and elsewhere, saying that Dred Scott was wrong. We do not need to follow this decision. During his presidency, Chief Justice Taney told Lincoln, let these guys go. You can't lock them up. Lincoln said, no, I determined that you're wrong. You are wrong, and I will not follow you. I want you to think very carefully about what happens when people start ignoring judges. Even if you may agree in these circumstances that Dred Scott was wrong, or that the locking up of prisoners was wrong without habeas corpus, do we want to give executives the power to simply ignore the courts? I discussed in the very first day, when you have governors standing in the courthouse doors or in the schoolhouse doors blocking access to little children to enter the building, he's ignoring court, saying, I think he's wrong. Do we want a society where people can say, no, I won't follow the courts? Even if you probably think they're doing the right thing, right? Dred Scott was terrible. Lincoln's opponent, Stephen Douglas, who actually beat him for the Senate, people forget that part of history, but the Lincoln-Douglas debates, right? Douglas won. Douglas won the Senate race. But Douglas said very clearly, even if this decision's wrong, we should not start ignoring court decisions. Maybe push for a constitutional amendment. That's one way of fixing it. But don't ignore things. Okay? So the history of Dred Scott is almost as important as the decision itself. I usually don't like to lecture quite this much, but I want you to get this history. Any questions about the history of Dred Scott and what led up to it? Anything in your minds? No? Okay. Let's get started. Where did I finish off last time? Thank you, ma'am. Okay. So I'll get you in a minute, but out of my place. So believe it or not, oh, you give a little reprieve. Believe it or not, Dred Scott is a civil procedure case. Dred Scott is a case about diversity jurisdiction. I know you probably burned diversity jurisdiction to the back of your mind. You said, oh my God, thank God, I'd never do this ever again. Well, my friends, we're back with diversity jurisdiction. But in a very important way. Sorry, my throat's still a little sore. Lauren, why do we have diversity jurisdiction? You cited this in CivPro, you probably never want to talk about it again, but what's the purpose of diversity jurisdiction? No, I don't care about Dred Scott. Just in general, as a matter of CivPro, why do we have diversity jurisdiction? Just go back to day one. Why does this exist in federal courts?
So,
what's diversity jurisdiction?
to prevent bias in the court.
Right. What's diversity jurisdiction? Yeah. Citizen of one state, citizen of another state. And why do we have, you said it, why do we have diversity? Local courts, right? Because you don't want the local form biasing in one part or the other, right? If you thought that this argument was silly, think about if you're a slave trying to sue for your freedom. Do you want to be in a Missouri state court, or do you want to be in a federal court? Federal. Okay. And this case actually had both. We'll do the facts in a moment. But before this case arose, there was another case called Scott versus Emerson. Dred Scott sued in Missouri state court for his freedom. We'll do the facts in a moment. Unsurprisingly, the Missouri Supreme Court said no, that we will not grant your freedom. Okay? Missouri Supreme Court said no. We will not recognize the fact that Illinois is a free state, and that gives you freedom. So as soon as he lost that case, what did Dred Scott do? He brought a second action in federal court, hoping for a more fair form, hoping for maybe a federal judge will give him a better shake. And what was his pathway, Jonathan, to federal court? What was his jurisdictional argument about why he belonged in federal court?
He was free in other states.
Who is the defendant? Who is the defendant? Dred Scott for Sandford. I know Sandford. Who's Sandford? Who do you think he'd be suing to get his freedom? His owner. Yes. So Sandford, right, duh, right? Sandford was a citizen of New York. So usually when a citizen of Missouri sues a citizen of New York, he can go to federal court. No question, right? Jonathan, was Dred Scott a citizen of Missouri? Technically, now, was he? What's the court say?
Court rules that he doesn't slave, not technically a citizen.
Okay, we'll go into this in depth, but I want you to understand this was a case by diversity jurisdiction. The entire nature of this case did not hinge on whether the Missouri Compromise was unconstitutional, or whether taking a slave away violated due process of law, right? The simple question, I don't mean to minimize this, but the actual question was one of jurisdiction. What makes someone a citizen of a state? Not a citizen of the United States. A citizen of a state for purposes of diversity jurisdiction. I'm sure you study this in Civ Pro, you probably didn't think much of it, right? If you move to a state, establish domicile, you have an intent to stay, you're a citizen of Texas, right? I moved here, I have a job here, I live here, I am a Texas citizen. So if I want to sue someone from, Texas, I couldn't do it because we're the same state. There's not, diversity is lacking. So here, Scott was saying, hey, wait a minute, look, hey guys, I was freed in Illinois or Minnesota or wherever, and I live in Missouri now. That makes me a citizen of Missouri. Let me go to federal court. Plowman, what would have been the very narrow way of resolving this issue? How could the Supreme Court have resolved this issue, gotten rid of it, and not created an entire mess? What would be really narrow way to do it? I'm asking, what would the most narrow decision have been in this case? How could the court have tossed this one without much effort? What do you think? If you were a judge in the 1850s and you wanted to resolve this on very narrow grounds, what would you have said? Yeah, period, right? The decision would simply say, under Missouri state law, right, he's not recognized as a citizen. Therefore, jurisdiction is lacking, dismissed. This was the concurring opinion which you saw, which was supposed to be the majority opinion. But again, we come back to Professor Snape, Lord Voldemort, or Roger Taney, right? He didn't want to just dismiss this case. He wanted to reach out and resolve the big issue, right? He wanted to find the Missouri Compromise unconstitutional, say the federal government could eliminate slavery, and make clear once and for all that even if freed, right? Even if Dred Scott was freed by his master, he would still not be a citizen because of his African blood. Right? Those three aspects of the decision, that people of African descent could never be citizens, the federal government cannot prohibit slavery, and taking away slave violated due process of law. He was effectively trying to legally enshrine the fact that blacks, no matter what, would remain a sub-second-class race, and the federal government cannot do anything against it. That was his mission. Did he succeed? No, but that's what he was trying to do. Okay. Any questions about the overview of the case? Yes, sir. Tell me more. I like that one. That's very good.
I don't really know what the underlying cause of action were. I don't know if it was a different cause of action.
Well, what's res judicata? Remind your friends who maybe forgot from Civ Pro. You're right. And this is actually a very important point. I said a few minutes ago that Dred Scott originally brought an action in state court in Missouri. Okay? After the Missouri Supreme Court ruled, he did not appeal that to the U.S. Supreme Court. What do we call that, Hector? He failed to appeal. He did not appeal the judgment. What's that word when you don't follow your necessary appeal? Waived. Waiver. The Missouri Supreme Court ruled against him on an issue implicating constitutional law. He could have appealed that to U.S. Supreme Court. He failed to. That's what we call a waiver. If you don't do this, you will get disciplined by the bar. If you have an appeal that you don't file, you did wrong by your client, right? So Hector, I think this was actually raised in one of the opinions. This was barred by res judicata. You can't go to federal court after the state court already ruled on the exact same issue, and you didn't appeal to the Supreme Court. So to add to Plowman's question, one page, res judicata, done. But this would not have made the issue go away because there's someone else, right? If it wasn't Dred Scott, it would be someone else who didn't sue in state court. So this is one of those cases where the Supreme Court said, okay, we're going to do this. The facts aren't the best, but we're going to handle every possible thing. But Hector, you're exactly right. This was a very bad case for a number of reasons, one of which was res judicata. Yes, sir.
Was there an amount of controversy regarding that?
Not for diversity. No, the amount of controversy is always for federal question jurisdiction. But there was actually no federal question jurisdiction at the time either. That wasn't until the 1890s. Yeah, believe it or not, there was not federal question jurisdiction for most of the 19th century. The only way to federal court was diversity. That was the only way, unless you had a federal cause of action. Yes, ma'am.
So how did a citizen raise a constitutional issue in a federal? They didn't?
No.
That sucks.
Well, why do you think there were so few Supreme Court cases, right? Unless there was some sort of federal cause of action, stuff was done in state court. It's remarkable to think about it. There were very few federal cases. I mean, before the 14th Amendment, there wasn't really much federal law. There wasn't much, so you weren't suing on stuff. Yeah, I mean, most cases were brought in state courts. State courts have concurrent jurisdiction to hear constitutional claims. And only on appeal to the U.S. Supreme Court did the issue actually get teed up. Yeah.
So was it just like the interpretation of the arising under?
Oh, now we're going to federal courts. I'll talk about that later. But the arising under question is a very complicated question. What's a federal question? That's a federal courts question. But we can talk about that after class if you like. Take federal courts. You'll like it. It's a good class. All right, so let's do the facts. Lauren, briefly, what were the facts in this case?
All the different places he
Well, start off, and maybe I'll stop going with it. Let's start.
Okay, so he was originally living in Missouri. Correct. Okay, so then he
Scott, by the way. He's Scott is he. Yes, that's fine.
So he belongs to this guy named Emerson. Dr.
Right.
Emerson.
So Emerson, Dr. Emerson was a Scots master, and he was a slave. Okay, good.
And so then Dr. Emerson takes another slave woman, Harriet.
Yep.
And under his permission, Scott and Harriet get married.
Good. By the way, this wasn't the fact that they needed permission. Slaves were not allowed to get married unless their masters consented. This was an actual contract under law. This is one of the rare exceptions where actually they were allowed to. It's unclear if they were legally married, but I'm pretty sure they were. Anyway, go on.
I think actually they moved to Illinois before they got married.
Okay, right. So the first, no, you're fine. I mean, the facts here are a little bit complicated. So the first step was Scott and this Emerson moved from Missouri, red state, right, to the blue state, Illinois. Okay, was Illinois a free state or a slave state? Yeah, good, free state, right? They remained in Illinois for about 2 years. Okay, Lauren, you're good for now. I'll move on. Okay, they remained. Don't worry, we have plenty of people calling. They remained in Illinois for 2 years. Okay. Michael, under Illinois law, what happens to someone who, what happens to a slave who enters Illinois? They're free, okay? This is a principle known as a case called Somerset's case, which is mentioned in the dissent. Somerset's case by Lord Mansfield. And it's actually a very beautiful thought. It was an English decision saying, the second you breathe one drop of English air, right? The English air enters your lungs, you are free. That you cannot be in England without slavery. Now, Mansfield said nothing about slavery in the colonies. So if you're in India or Africa, wherever, you can be a slave just fine. But if you are in England, you get free air. So by extension here, Illinois said once a slave enters our state, he's free. Fine.
I think that's silly, but like, did people know that? So why did he take a slave into Illinois and expect everything to be fine and to be able to keep owning his slave?
Okay, so I'm going to ask Michael the follow-up question. What, Michael, this question, does merely being in Illinois make you free, or do you need a court to set you free? Okay, and here's the important point, right? Merely bringing a slave into the state wasn't necessarily sufficient to emancipate means free, a slave. Scott would have had to need to go to a court in Illinois to appear and say, I'm free. Lauren, do you think Mr. Emerson allowed Scott to go to a court? Why not?
He didn't want his slave to be free.
What would have happened if Scott would have ran away and ran to a court? Yes. And here's the thing, right? The second Scott's a runaway, he left Emerson's side under the Fugitive Slave Act. He'd have to return to his master. And I don't think it would be very well for Mr. Scott. So while it's very nice to say that Scott could have walked to an Illinois court, oh, wow, there's a judge. Let me go get my freedom, right? Let me go sue. Okay, where the heck's he getting a lawyer from, right? Where is he getting representation? This is not an easy process. Like, there were abolition societies, so Scott would have had to actually snuck out, as master knowing, gone to a court, obtained a lawyer, sued his master, and went through the proceedings. Not very likely, right? So even though he was in Illinois for 2 years, there was no judicial declaration, okay? And then what happened, Sarah, after he's in Illinois for 2 years? No, we're not suing yet. After he's in Illinois for 2 years, where do they go? What's the next stop on the journey? No, not New York. Where do they go? Sarah? What's in Minnesota? One at a time. You have it? No? So where do they go? Haley? What's in Minnesota? What's the big deal about Minnesota? What's the issue there? No, the master, the second master is from New York. Sean? Sam? What's the deal in Minnesota? Minnesota, right? What's the deal there? Demi? Sorry, Chloe. Was Minnesota a free territory or a slave territory? It's free. By what rule was Minnesota a free territory? Okay. So here's the issue, right? After going to Illinois, which was a free state, they moved to Minnesota, which at the time wasn't a state yet. It was still a territory. And under the Missouri Compromise, any land north of this line would be a free territory. Okay, and the same deal applies. Scott didn't go to any court in Minnesota to sue his master and seek his freedom, right? He traveled to Minnesota. Okay, and as it turns out, along the way, he had a couple kids. One of the kids was born in a free state. One of the kids was born in a slave state. And he was married along the way. Okay? This was an interesting test case because it wasn't just Dred Scott suing for his freedom. He was suing for his freedom of his family. Because one of his kids was actually born in free territory. Okay? So it wasn't just Scott. It was actually his entire family was at issue. Okay? But then Scott is brought back to Missouri. Okay? And as I said, the first lawsuit was filed in Missouri. The second lawsuit was filed in federal court in New York, which is why I think a couple of you might have misread it, but the suit was actually filed in New York. Okay? What's the significance, Ian? What's the significance of the fact that Scott was brought back to Missouri? Okay. Ian, let me ask this follow-up question. Is Missouri required to recognize the determinations of Illinois law? Is Missouri required to recognize the fact that under Illinois law, Scott would be a free man? Why not? I'm sorry? Missouri law. What about the full faith and credit clause? Didn't we study that Missouri has to give full faith and credit to all the judgments and decisions of Illinois? What do you think, Connor? Doesn't Missouri have to give full faith and credit to all the judgments of Illinois?
I mean, I think so, but in practice, actually,
Is there a judgment here? Was there a judgment from Illinois saying he was a free man? Ah, so here you see the rub. The full faith and credit clause refers to judgments, proceedings, things of that nature. There was no proceeding. Scott never sued for his freedom in the other places. So Missouri was under no constitutional requirement to respect the judgment of Illinois. Okay. What's interesting, though, and this was mentioned in the case, is that before Dred Scott, Missouri did respect Illinois law at this point, right? They did say, okay, if you're a free man in Illinois, we'll treat you as free. But the Missouri Supreme Court reversed that precedent and said, you know what? Going forward, right? Going forward, we are not going to respect foreign judgments about free slaves. We're not going to respect foreign law about freeing slaves. Yes, ma'am.
I'm sorry, I don't think it's Fort
Yes, Fort Snelling was in Minnesota. Okay. Everyone got that? Fort Snelling was in Minnesota? Yeah, it was in the territories. So hand up.
No, I'm
Anyone? I'm sorry. Yes, ma'am. Before Dred Scott, Missouri recognized foreign law about freeing slaves. Right? So before Dred Scott, if a slave was freed, Missouri would recognize that. But in Dred Scott, they changed their precedents. They said, going forward, Missouri will not recognize any out-of-state emancipation. Yes, sir.
All right, so in this case, Dred Scott was not acting for because he didn't go to court.
Well, it depends who you ask, right? Under Illinois law, he was free the second he stepped on the soil, right? But under Missouri law, where this lawsuit was brought, they don't recognize that principle, right? They say there has to be an actual judgment, which they would probably have ignored anyway. Yes, ma'am.
So actually, in Illinois, you didn't really have to go to a court.
Under Illinois law, the answer is no.
But Missouri was like, that's a one-way rule.
Yes, ma'am. Because they'd be required to the full faith and credit clause. Knowing full well, though, that there's no way Scott could have gotten a lawyer and got to court. It just wasn't even possible. Yes.
wasn't marriage even then an institution recognized between citizens?
So that's an interesting point, right? The issue, the dissent makes this point about recognizing marriage. I don't know if Scott was ever actually legally married. I think they've been a common law marriage, but it was a marriage nonetheless. And generally, if you got married in one state, another state would recognize it. And that has been the law since time existed. And there's only come to the forefront now for the same-sex marriage issues, where some states don't want to recognize foreign gay marriages.
But if they have been recognized as marriage, it's citizens.
I don't think you need to be a citizen to get married. The dissent makes this point. I think the dissent's probably wrong. I think non-citizens can get married. Because even in slave states, blacks get married. So I don't think slaves can get married. Yes, sir.
What was his actual cause of action that he brought?
Emancipation.
It was emancipation.
It was a recognized cause of action that you could sue for emancipation.
See, I thought it was assault. Whenever I went back in, I mean, I read it was assault, so I didn't know.
I mean, there may have been some assault claims, but effectively, let me put it this way. He was trying to get a federal court to declare that he was a citizen. And once he was a citizen, then he could sue for his freedom. So even if this initial claim was one of assault and battery or whatever else in court, it was premised on having a declaration as a citizen. Does that make sense? Yeah, there may have been some other stuff, but
But
this
I know
was,
it's kind of relevant. I knew what he was trying to get, I just didn't know.
he needed a declaration that he was a citizen, because once he was a citizen, he could sue for emancipation.
This is a question you mentioned earlier, one of his children was born in a free state. What is the situation there if a child is born in a free state? Does that grant the child freedom, or is it the same sort of?
Well, this was the third aspect of Dred Scott. Scott said anyone of African descent, Connie said anyone of African descent, no matter where they're born, even if free, can never be a citizen. You see, this is why Tawney had to go as far as he did. What do you do about the child born in Illinois, right? The child born in a free state. Tawney said, if you are of African blood, and he said this in very brutal language we'll discuss in a few moments, you will never be a citizen.
And before that, was that still used?
That part of Tawney's decision was wrong, because there were free blacks born in northern states who were full citizens under state law. So in that sense, Tawney's decision actually nullified New York, which gave citizenship to free blacks. Yeah, but that part of Tawney's decision was total. I mean, all of it's wrong, but that one was actually, you know, legally, technically, and practically incorrect. All right, questions before we move on. We are not done with this case, not by a long shot. But any questions? The reason why it's a 30-page case. There's a lot of moving parts here. Okay, so we have the decision, right? Is there jurisdiction? Okay. Tawney's decision raises an important question. Does the Constitution define citizenship? Jacob, does the Constitution, as originally drafted, define citizenship? Does Congress define citizenship? Well, let's be very precise, right? Article 1, Section 8. Does Congress have power over citizenship or naturalization? Jacob. I'm sorry? Grishma? You're right. Good guess. Good. Under Article 1, Section 8. Under Article 1, Section 8, right? Congress can provide rules for naturalization. It's on page 23, right? Naturalization. That means aliens coming into and out of. But Krishna, you're right. Was there anything in the Constitution saying Congress defines who is a citizen? No. And this was actually a weird open question. For the first many years of the Republic, there wasn't really a thing as a citizen of the United States. All you had were citizens of states. And it was widely presumed that if you were a citizen of one of the 13 states, you would also be a citizen of the United States. Makes sense. Which brings us back to Article 4, our favorite, right? We discussed this now a half dozen times, page 33. Article 4, Section 2. It says, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. We've discussed this a few times before. Privileges and immunities were these rights, these certain, liberties which people had. But these weren't held only by people of states. They were held by citizens of the state. So if you're a citizen of, South Carolina, and then you travel to Georgia, Georgia would need to treat you the same way it treats its own citizens. Right? But Maurice, who determines if you're a citizen? Yes. The state determines if you're a citizen. So Maurice, let me ask you this question. If, say, a free African-American person from Illinois goes into Missouri, not a smart move, but let's say he goes into Missouri, right? Bad move, right? Would Missouri be obligated to treat him as if it was one of their own citizens? He's a citizen in Illinois, no question, right? But he comes down to Missouri. Would Missouri be required to give him these privileges or immunities? Well, I like your answer, but even before Dred Scott, how do you think Missouri would have acted? They said, you're not a citizen. Everyone get that? The determination of who a citizen is, right? This word right here, who's a citizen? This is a factor of state law. If Missouri won't recognize a citizen from Illinois because he's black, then when he comes to Illinois, when he comes down to Missouri, he does not get the privileges and immunities. And so then, Brandon, let's talk about diversity jurisdiction. The jurisdictional statute simply says, citizen of state A can sue citizen of state B. There's federal diversity jurisdiction. That's simple, right? Who determines if you're a citizen of state A? What determines that? Marie said it a moment ago. Yes, the law of state A. Everyone follow me? So in order to sue in federal court, even under today, you look to the law of the state. Is the person domiciled, right? Do they have the intent to stay? These are all questions of state law. Even though it's a federal diversity statute, it's a question of state law if you're a citizen. The reason why this clause was so important is that citizens were entitled to all these rights, which were routinely denied by southern states to blacks, even if they were citizens from another state. The first part of Taney's decision had to make clear that blacks, whether free or not, could never be citizens. Because if they were, they would be entitled to these various privileges and immunities. Morgan, Taney makes something of an originalist type argument where he looks to the history of our country and various founding documents. How does he rationalize the fact that blacks were never meant to be part of this body of right holders?
Looks to the framers' intent and takes a very particular view of the three documents, the Declaration of Independence, Articles of Confederation, and the Constitution, and manipulates those in order to support.
Oh, you say he manipulates them. How does he manipulate them?
Well, there's notes that follow that say this is a little worrisome because you can decide what you're going to, how you're going to draw and manipulate the text of the Constitution in order to get to that result. And so the dissent says that he did this, but he uses the three separate documents to support.
All right, let's walk through them. So go to page 9, right? Declaration of Independence. We studied this in the very first day. Lauren, it says, right? Famous line we always read on the 4th of July. We're eating our hot dogs and hamburgers, right? We hold these truths to be self-evident, that all men are created equal, right? How does Taney read that phrase, that all men are created equal? What does Taney say about that?
Well, he basically says that by men, the founders meant the free men at that time, as well as the white race. Because at the time, the African were an inferior race, and they're not seen as property. So they're not included.
Okay, so first Taney says, well, Jefferson wrote this phrase, all men are created equal, but at the time the Declaration was written, this simply wasn't the case. Africans were treated as chattel, as merchandise, the same way you would throw luggage in a boat. You throw people, you bring it with you wherever you go, right? He calls it an inferior and unfortunate race. He then, beginning of the Constitution, right? Page 17. We the people, right? We the people of the United States. Zachary, how does Taney read that expression?
It basically kind of talks about the framers also thinking that they're educated
know in the literature that they want to include people to African Americans.
Right. And Tawny discussed earlier, look, you have the Fugitive Slave Clause, you have the 3/5 Clause, you have the slave trade laws, you have all these other provisions which specifically say not exactly part of the we the people. You have this provision which says citizens of each state. If the blacks were not citizens, how can they possibly be part of this body of the people? Okay. So it's really interesting is that the Declaration of Independence was rallied by the abolitionists as this promise, right? Listen, it says, all men are created equal, we the people. But Southerners who support slavery had to reject the Declaration because the language didn't support their worldview that people were not equal. So what does Tawney do? And this is the part that maybe you weren't taught in school. Tawney says, well, if the framers meant what they said, they couldn't have possibly written this, right? If they actually meant for blacks to be treated equal, they couldn't have possibly written this because that wasn't the case. Okay? And there is a certain appeal to this argument, but I think there's also a certain weakness, right? We turn back to page, to page 17. Let's keep reading, right? We the people of the United States, in order to form a more perfect union, a more perfect union. Most people stop at the first three words, but I like to keep reading. Read the entire thing, if you will, but I like to keep reading at least that far. The framers of our Constitution were fallible men, right? In no way to justify them, but they were fallible. They made very bad mistakes. But they recognized quite implicitly that they were wrong. If you read the writings of Jefferson and Washington and others, they were torn apart about slavery. They didn't do the right thing as we would judge today, but they recognized it. What I want you to appreciate is this phrase, more perfect union, represents not an end point, but a beginning point, right? This wasn't meant to be the final document to live forever. It was a document that would be amended. And we see with the 14th Amendment, a bloody civil war was fought over this. So while it's very easy to dump on the framers as being a bunch of white male, racists, and I'm sure this is what you were taught in school, I would provide a slight counterpoint to say that they recognized that this would not last. The slave trade ended in 20 years, right? People recognized from the earliest days that this would not prevail. Another point that I want to stress, and it's very nice that we're writing the 50th anniversary of Selma, is that Martin Luther King analogized the Declaration as a deposit, right? As a deposit. That this phrase, all men are created equal, was a deposit, a promise, if you will. It maybe wasn't true in the 1770s when it was written. But over the course of years, we moved closer to that promise. We're there tonight, we can argue for forever. But we at least try to move closer to that issue, right? So the struggle of American history for the first 150 years was largely about the issue of slavery and race. And the next century, too, was largely about that issue. So Tawney's decision takes a very unfortunate view of this history, which, as a matter of course, was wrong. At the time of the American Revolution, at the time of independence, at the time of the Constitution, states had begun to grant citizenship to Africans. States had begun granting freedom. You had free states where slavery was prohibited. And when people learned about this issue and started talking about it, they got rid of it. And those that refused tried to leave the Union over it. And a bloody civil war was fought over this issue. And from the Civil War, we gained 3 amendments to the Constitution that sought to radically transform the relationship between the state and the federal government. No longer would the states be trusted to protect rights with respect to race. Now the federal government has the power to ensure about this. This was enshrined into our founding documents. Okay? And we're still not there yet, right? We're not necessarily there yet. But I want you to keep in your minds as part of forming a more perfect union, something we all do every day of our lives. And you are soon going to be lawyers with the power to do stuff and protect clients and everything. This is part of your mission, I hope, as well. Okay? So even if Taney is perhaps historically in the ballpark about how the Constitution was framed, I think it mistakes and ignores significant struggles fought over it at his time and as a result of his decision afterwards. Okay? All right, any questions? Yes, ma'am. What's the argument of the Commerce Clause?
That by not allowing free men to travel from state to state, the Congress has the right to.
Wouldn't that require calling a person an article of commerce? Wouldn't that be counterproductive?
I know, that's why
I mean, yes, I suppose you could label a person an article of commerce and therefore moving like merchandise is interfering with interstate commerce, but first of all, you're like 60 years before the Commerce Clause even expanded anyway. At the time, the Commerce Clause was very narrow. Second, this would actually require you to say that slaves were articles of commerce, and I don't think that would do very well for Mr. Scott. Other questions? But interesting idea. Good constitutional thinking, but I don't think it gets that far. Yes, sir. There was no federal question jurisdiction in 1853. None. That's why we did diversity. And let me ask you about what would the federal question have even been? See, there was no 14th Amendment. There was nothing requiring in the Constitution states to give citizenship. What would the federal question have even been?
I guess whether
Look, this is what you had, right? This was the only provision of the Constitution you had. What do you sue under? This is a litigation strategy. He had to get a declaration that he was a citizen, which would mean he then gets privileges and immunities, which means he can sue for his freedom. That was the path. That's why he moved to the federal court. He had smart lawyers, right? This wasn't, the abolitionists chose this as what we call a test case because he was married, right? Because he was both in a territory and a free state, and he had a kid in a free state. He was like the perfect test family to try and resolve this issue. Yes, ma'am.
Back to Morgan's question, like, is it only because the Commerce Clause had not even, wasn't even used, that it wasn't expanded enough that, like, that slaves would have to be called an article of commerce? Like, because isn't it just anything now that drips over?
Yes, that's the law today, but that didn't exist back then.
Right.
I'd actually argue one step further. The Commerce Clause would go the other way. If Illinois is depriving Mr. Emerson of his slave, Illinois is interfering with commerce. Follow me here. If, in fact, a slave is an article of commerce, Illinois, by emancipating, will be actually interfering with the Dormant Commerce Clause. And they will be interfering with interstate commerce because it is property. That I think, will be the logical implication of the argument, which is not what Mr. Scott wanted. Right? In effect, the slave master in Missouri could have sued, saying that Illinois law interfered with his commerce right, interstate commerce rights. That could be like Macaulay, Gibbons or Ogden. That would not be what they want.
All right, how's this not a due process thing?
Let's talk about due process. Good. Let's talk about due process, right? Because this comes up in the opinion. The Due Process Clause says the federal government cannot deprive someone of life, liberty, or property without due process of law.
And it's in person.
Yeah.
So whether you're a citizen or not, can't be deprived of due process.
Let me go back to the rotation. Jonathan, how did the due process argument work in this case? What did actually Tawny say? I'll come back to you in a minute, Joe.
Because he wasn't a citizen.
No. Whose due process rights were violated by this case?
Slave master?
Yes, the master's property rights. So follow me here, folks. It says that you cannot be deprived of life, liberty, or property without due process of law.
He says his Fifth Amendment has his property been taken from him.
So the argument goes, Minnesota, Fort Snelling, right, was a free territory. Did Congress have the power to deprive Mr. Emerson of his property? More so, Gabrielle. What is the effect of the act of Congress which takes away Mr. Emerson's slave? Yeah, what's the problem there under the Fifth Amendment? Yes. So here, what's interesting, and we haven't discussed the due process clause, but I'll give you a brief introduction here. There are two ways of reading the due process clause, right? One you can call maybe procedural. If you want to take away someone's property, the government needs to give them procedure, a hearing, a trial, whatever, right? You can't execute someone without a trial. But there's another way of looking at it. I mentioned before. This word liberty in the due process clause isn't a fixed blot of ink. It has a substance to it. It has meaning. Okay? The second strand is often called substantive due process. The first is procedural. The second is substantive, because this word liberty has some meaning to it, some substance. So the argument goes like this. Possessing a slave isn't just a property right. It's a liberty interest that the master, follow me here, the master has a liberty interest in owning a slave. And the federal government, by taking that away, by limiting slavery, violates that liberty interest. This is one of the first instances of where a federal court found the government violated what was known as substantive due process. We'll discuss later why people don't like substantive due process, because they give judges license to perhaps invent rights out of whole cloth. But a very common attack of substantive due process is, oh my God, this was invented by Dred Scott. It can't possibly be good. Well, doctrines may exist outside of where they were created or first used. So we'll discuss this later. But what Tawney held was, by prohibiting slavery in these northern territories, Congress actually took away the liberty of the master without due process of law. Everyone get that? Now I want to go back to Job's question, which was a very good one. Job says, wait a minute. The Fifth Amendment applies to all persons, right? Wasn't Dred Scott's liberty taken away? Job, was that your question?
Yeah.
Right? This is how you might read it. Wasn't the slave's liberty taken away? Tawney read the exact opposite. It wasn't the liberty of the slave. It was the liberty of the master. Isn't that perverse? Right? It's not the liberty of Dred Scott's slave. It's liberty of Mr. Emerson, the master. Okay? Now, I know that sounds crazy, Emily, but could it have actually been the case under the Fifth Amendment that any slave could claim a right under the Fifth Amendment to become free? Could any slave have filed a lawsuit under the Fifth Amendment claiming to be free? Who does the Fifth Amendment bind? No. Who does the Fifth Amendment? Yes. The Fifth Amendment binds the federal government. Emily, under which laws was he being enslaved? Was it state law or federal law? State law. So everyone see the issue. The Fifth Amendment only binds the federal government. Dred Scott was enslaved under a state law. He could not have sued under the Fifth Amendment for requiring him to be a slave because there was no federal law requiring slavery. The only federal law that existed prohibited slavery. So you see, the federal law that prohibits slavery impacts the liberty interests of the master. But there is no federal law which requires him to be a slave and nothing that he could challenge. All of the laws concerning slavery were based on state law. And until the 14th Amendment was ratified, the states were not bound by the Constitution. This is why the 14th Amendment was so important, because now the states are bound by due process. The states are bound by equal protection. But at this point, the Fifth Amendment only applied to the federal government, which did not mandate slavery. Therefore, as perverse as this sounds, this part decision was probably legally correct. Not all of it, but the fact that Emerson's rights were protected by the Fifth Amendment. Whether this was a deprivation of due process, I think it's ridiculous. Right? One of the first aspects of any kind of natural law is that you own yourself. You can't own someone else. But the fact was, under the Fifth Amendment, Emerson was the one to bring a due process claim. Everyone get that? It's a really important part, but it makes the 14th Amendment so much more significant. Everyone with me so far? All right, so where are we, right? Tawney makes a number of points. First, he says, people of African blood, of African descent. And by the way, he means one drop, to use the Nazi reference, right? So-called people of mixed race, right? They were considered black. By the way, I don't want to belabor this point. I'll get to it later. But Homer Plessy was 1/8 black. According to reports, phenotypically, he didn't really appear black. He was fairly light-skinned, and that we don't have a picture of him, so I can't prove this. But newspaper accounts of the time did that. But under this ruling, anyone with even a drop of African blood was deemed slave, not citizen. Right? So that was the first aspect. Then Tawney goes and holds that the law in the territories by Congress, which deprive people of their slaves by banning slavery, violates the Fifth Amendment and violates due process of law. Third, Tawney holds that Missouri is not obligated to respect the laws of Illinois. So even if under Illinois law, he had taken that breath of fresh air, that breath of freedom, right? Missouri was under no obligation to respect that. Everyone get those three parts of the opinion. The other part of the opinion, which I don't really care too much about, but I'll mention briefly, is about the Territories Clause. This argument was just stupid. It's ridiculous, but I'll explain it briefly. So the Constitution says that Congress has the power to pass whatever rules and regulations for the territory of the property. Okay? So it's under this ground that Congress passed rules governing Minnesota and Fort Snelling. What does Tawney hold? This is ridiculous. He says, well, that only applies to territory that existed at the time of the Constitution. It doesn't apply to any new territory the United States may acquire. Okay, I can't even defend this one. It's silly. But by doing this, he says, therefore, Congress has no power to enact any rules whatsoever in the Northwest Territories in Minnesota. Therefore, the Missouri Compromise is unconstitutional. So in effect, what happened here, right? Let's go back to our map. Missouri Compromise is unconstitutional. Therefore, slavery could exist anywhere north of the line. Any person of African descent, whether north or south, was not to be treated as a citizen for purposes of federal law. Any slave who managed to get to the northern courts and was returned back home, their states would not be obligated to respect it. Taney's decision had the effect of keeping people of African descent in a permanent state of bondage. There was no out. This line was gone. There was no more Northwest Missouri Compromise. Sarah?
You said that part of the problem is that you have no law to challenge.
Who's he?
That's right. Because if slavery has their rights to property, and sorry, I can't follow you.
That's good.
I think what you said is that the amendment binds the federal government to Dred Scott and federal law.
Yes.
So what about like all the slave like those laws that are like usually slave acts?
Oh. Okay, so here's what's interesting, right? The Constitution has a future slave act that says if any slave escapes a southern state and goes north, that's return it, right?
Yeah.
Sarah, let me ask you a really important question. Which came first? The Fugitive Slave Clause or the Fifth Amendment? Historically, which came first? No. Which came first? The Constitution and the Bill of Rights? Right, and the Bill of Rights was ratified later, right? This is a very important question. Did the Fifth Amendment render the Fugitive Slave Clause unconstitutional? Whoa, that blew your mind, right? Can a later amendment make part of the earlier Constitution unconstitutional? Can the Constitution be unconstitutional? Well, the answer is yes. The 14th Amendment nullified the Three-Fifths Clause, right? The 14th Amendment says equal protection. No longer can a person of African descent be treated as three-fifths of a person. So, Sarah, your question is a very good one. A lot of abolitionists argued that in light of the Fifth Amendment, the Fugitive Slave Clause was unconstitutional. A lot of people actually argued, abolitionists, Frederick Douglass and others, that under the Due Process Clause, slaves did not have to be returned. And their argument's not crazy, right? And Job said it. The Fifth Amendment's not for citizens, it's for persons, it's for everyone. All federal action. This question was never resolved. And we don't have any, actually I shouldn't say that. We do have an opinion on it. A case called Prigg v. Pennsylvania, which is mentioned in the reading. Opinion by Justice Story. And Justice Story basically upholds the constitutionality of the Fugitive Slave Act. Because effectively what happens like this. Pennsylvania tried passing a law. They thought they were really cute, right? Pennsylvania passed a law, big abolitionist, I think. Under Pennsylvania law, no one in Pennsylvania shall assist the return of a slave. Right? So if you have a runaway slave from Maryland to Pennsylvania, Pennsylvania law says we will not assist the return of a slave. Supreme Court decision, Prigg v. Pennsylvania, said that law is unconstitutional because it violates the Fugitive Slave Act. So that court effectively upheld the Fugitive Slave Act. So there's that. So your instinct, Sarah, is directly on target, but the courts more or less did not agree with you. I think you're probably right, but at the time the courts did not agree. Other questions? Yes, ma'am.
You mentioned the one drop rule, and I think one thing a lot of people don't realize are historically there's so many politicians that did have a lot of African Americans in their blood that isn't talked about at all.
That's a good point.
Before President Obama, I'd say there's like 6 or 7 presidents that had a lot of African Americans in their blood.
Mhm.
Thomas Jefferson. There are a lot of people in, I believe his mother was an Indian. His father was half African American descent. There's just so many people. Alexander Hamilton, for example, was left. And that's what I feel like
Mhm.
And we like to learn about, the ones y'all know, and Plessy in 8, black. And he was treated this way, but, you have to realize that these things work in favor for whites. If it's something that was a beneficial thing, then I feel like it was a way to either work for them or against them in a lot of different senses. But I just say this to, remind people in this class, because I feel like, we talk about, these touchy subjects, and I just want people to realize that, yes, this one-drop rule is true, but it was not always applied, if that makes sense, because, I don't think anyone in here, and maybe I'm wrong, maybe some of you did know these things, but a lot of these people that we have talked about in this class had a lot of African American blood in them. So I just wanted that to be known.
Okay, thank you.
That's something that we realize.
Thank you. I think it's a very fair statement. I mean, the issue in Plessy, where they discuss, we don't need to decide how much black is black, right? They discuss at the very end. This was a live issue. And the southern states built these entire caste systems based on how much African blood you had, whether you were, and I'm going to use these terms, they're probably offensive, but I want to use them, quadroon, octoroon. These were terms to discuss what percentage of African descent you have. And there were actually entire mulatto, mestizo, there were all these terms made up to describe people of various descent, which was actually an aspect of control, saying, well, I may have some black, but not as black as this guy, right? Yeah. I may have a great grandfather, but see, his uncle is black. So you go down these different. I'll use the word eugenic, which is a word that came prevailed during the Nazi era. But this fixation on how much race, and yeah, we're all mixed. We have we all have various descents that come from different things. Anyone ever seen 23andMe? Sorry, I got 2 seconds. Anyone ever used 23andMe? Anyone know what this is? So 23andMe is this service where they'll swab your cheek, right? And you do your DNA. And they will say, going back thousands of years, what is your racial composition? I promise everyone in this room will have some African descent. I promise you everyone in this room will. Maybe one, but maybe if you're like Icelandic or something, whatever. But virtually everyone who has any American history will have some. You all have some Neanderthal blood. You have some Asian descent. I mean, everyone has some mixture. I think your point is well taken. Yes, ma'am.
I just had 2 points. First of all, do not use the child for anyone who actually is
Yes.
that. And 2, isn't it genetically
Oh God! Now you're going beyond my can. We can talk about that after class. Construct. No, I mean, this is beyond my area of expertise, so I will. No, that's quite all right. Construct, though. I left that word behind in grad school, but I think you raise an interesting point. I don't have any. My constitutional knowledge is limited, but I think it is a fair point. So one at a time, everyone.
Scientists say that what differentiates races is being able to reproduce. So two species of birds can reproduce in different races.
Mm-hmm.
So that's certainly not a problem for us.
Okay, very good. Yeah, all fair points. All right. Anything else? Okay. All right. Thank you for the discussion. I appreciate it. It's not often in law school you can talk about these kinds of things, but I do appreciate the perspective everyone brings to class. Okay, so the dissents lay out in some detail why the majority opinion is wrong. Okay? The dissent says, wait a minute, it's simply not true that at the time of the Constitution's founding, blacks were told unequal. Some states granted citizenship, right? Some states had the right to vote to Africans. The dissent also makes a point that this argument about the Missouri Compromise is ridiculous. Of course, Congress can make rules for new territory if it requires. But I think the point that dissent makes is strongest is why are we doing this? Right? Why are we reaching such a when the question before us is narrow? If our only question is, can diversity jurisdiction be prevailed upon, why don't we stop there? Why do we need to blow up the entire issue in a way that very well may lead to war? Why do we need to tell northern territories they can't have a ban on slavery? Why do we need to tell people that you don't need to respect foreign law about courts? Just say, under Missouri law, he is not a citizen. Done. One page. Or as Hector said, I think it was a fair idea, res judicata. This case was already resolved, dismissed. But Tawney went much further than this. And the dissent, and I'm sorry, the notes afterwards do a good job sketching what came after. So as I mentioned, Lincoln, among others, made the point very clearly that Dred Scott was wrong and that we're not required to follow an incorrect decision of the Supreme Court. And that raises a host of issues about what happens when presidents decide that courts are wrong. And when you start ignoring courts, as Lincoln did often, what happened? The other aspect is this decision didn't go away with the 14th Amendment, which is why I do these things out of order. Even though the 14th Amendment, on its face, reversed Dred Scott and guaranteed equal citizenship and guaranteed equal protection of the laws, as a matter of practice, the Supreme Court quickly retreated. Was your hand up? Okay. The Supreme Court quickly retreated. So we did one case last week, which was the civil rights cases. And this considered whether Congress could pass a law that prohibits discrimination on the basis of race in hotels and restaurants, other places of public accommodation. The Supreme Court said no. Congress can only act on states. Congress cannot act on individual parties. We did that case last week. But the main case, the case which I'm sure you've all studied and learned about at various points in your career, is a case called Plessy versus Ferguson. I'll get to the railroad company versus Brown case in a moment. But let's talk about Plessy for a minute. So again, there is no photograph of Homer Plessy. We don't know what he looks like. If you Google it, there's some image that someone says it's him. It's not. We have no known recording what the guy looked like. Also, this is also kind of perverse. We don't know if this is actually his grave. It's so surreal that such a significant figure in history has such a uncertain past. But this is purported to be his grave. It probably is, although I've seen reports that it may not be. But this is apparently where he's buried. See, what happens, a lot of people want to take credit for him and want to say, oh, he's in my cemetery. Oh, he's in my cemetery. It's a drug. I'm not making this up. People actually fight for visitors. Before internet, this is what you do. You visit graves. I don't know, right? So this is probably a Homer Plessy's grave, although we don't know for sure. There are various plaques about him throughout Louisiana. I found this one in the Library of Congress. This is actually his birth certificate from Orleans Parish in New Orleans. Now, who's Ferguson? Right? We said Dred Scott v. Sandford. Sandford was his owner. Who the heck is Ferguson? Ferguson was the judge in New Orleans. Why? What is another drawing of him? Right? Why was Homer Plessy suing a judge? This is Ferguson's obituary, or his obituary, right? Why was Plessy suing? Why was Homer Plessy suing a judge? So the facts of this case are quite interesting. Okay. This is what we call a test case. We've done several of these throughout the year. Okay. George, what were the facts here? What happened to Mr. Plessy?
Homer Plessy is the one who looks at, like, basically, he looks at the white person, except for the fact that he's like great black. He tries to avoid a train in Louisiana that says white only,
Mm-hmm.
and he gets arrested because he's not supposed to vote for him, and then he gets arrested, and he brings state board for the amount of how black he is, right?
Okay, that's good for now. Okay, so here's the facts. I found this newspaper article. It's from June 9th, 1892, from the Times-Picayune, and I'll read it to you in a second. But this headline, and I'm going to read it, but to give you a sense of how it's covered, it said, "quote A snuff-colored dissent of Ham kicks against the Jim Crow law and takes the jail end of it rather than comply with its distinctive provision." So let me read you a little bit of it. Yesterday afternoon at 4:15, Detective Kane arrested from the East Louisiana Homer Adolph Plessy, a light mulatto, and locked him up in the 5th Precinct Station on a charge of violating section blah, 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 relative to separate coaches. Captain Kane, speaking of the incident of the arrest, stated that he and the conductor had ordered both the man from the white coach into the one set apart for colored people. The Negro refused to leave the coach, saying that he had bought his ticket and was going to ride to Covington. Captain Kane here told him he would either have to retire to the other coach or go to jail, to which the Negro responded that he would sooner go to jail than leave the car. He was arrested. Okay, so this is the part that George was talking about. Previous to arrest, the conductor asked, quote, "Are you a colored man?" "Yes," was the answer. Then said the conductor, "You will have to retire to the colored car." The man refusing. Captain Kane was invoked, and entering the car, he said to Plessy, "If you are colored, you should go into the car set apart for your race. The law is plain and must be obeyed." Okay. Then said upon which the affidavit is based, and it was a Jim Crow car bill. Okay. And then they give the text of the law. All right. And he had to pay, he was arraigned, and the judge committed him to a bond of $500, which was signed, and Plessy was released. So if you want, you can read the rest of the article. I skim most of it. I have it on the blog. This is actually what the train station looked like, which was more or less here. Okay. This is actually an issue of his bond for $500. I've done a lot of research on this case, which I find fascinating. Okay. So this case goes up to the Supreme Court of the United States. Believe it or not, before the 1890s, there were not Jim Crow laws in place. The majority opinion makes it seem like these laws are of long vintage, as if they've been here forever. But it simply wasn't the case. States started to enact these various segregation laws following Reconstruction when the Union left, their occupying state. The law in Louisiana, I think, was passed in 1887 or so, so it was only a few years old at this time. Plessy, again, who was I think had a black grandfather or something, looked phenotypically white. And he challenged this because he wanted to make sure that he had a good case. He wanted to make sure that they were rejecting someone even who perhaps appeared white, but who had African ancestry. Okay, so we go to the Supreme Court. The vote in Dred Scott was 7-2. The vote in Dred Scott was 7-2. The vote here was even worse, 8-1. Okay, And by a vote of 8-1, the court upheld this Louisiana law, notwithstanding the 14th Amendment. Okay? James, how does the court grapple and square away the 14th Amendment here? How does it reconcile the 14th Amendment, which says in pretty clean language that no state should deny to any person the equal protection of the laws? Good. So this is the holding which everyone taught. It says that separate train cars. You have a car for blacks. You have a car for whites. That's equal protection. But I want to drill down into this more. Pedro, let me ask you this question, right? Under the majority's reading of the 14th Amendment, can a state treat people of different races differently?
No.
No?
Well, they can, I mean,
Let's be very precise. Can a state, under this law, under the majority's reading, make a classification based on race?
they can, but like the idea here, they can't, they can separate them, but they have to treat them.
Gabriel?
It says that it doesn't infringe on privileges.
What does that mean?
It doesn't infringe on the
Okay, good. Yasmin, let me ask you this question a different way. Is there anything under the majority's reading which says states are prohibited from considering race when making governmental decisions? That's right. Why not? Okay, good. Under the majority's reading of the 14th Amendment, all that is required is that the law be applied equally. That the law be applied equally. Right? Let me explain this in some detail. What does separate but equal actually mean? It isn't just saying you can have white cars and black cars, right? That's what we're taught in elementary school when we learn about this case. What it actually means that if Louisiana passes a statute saying that you shall have a separate white and black car, and whites can only go into one car, and blacks can only go into another car, it means you cannot enforce that law discriminatorily. What do I mean by that? What if a white passenger had tried to go to the black car? Well, under the equal protection of the law, they would have to kick out the white passenger and say, sir, you have to stay in the white car. Okay? So in theory, at least, I'll get to what actually happened. In theory, at least, right? As long as the law was applied equally, as long as blacks and white were equally treated under the law, it didn't matter if the law made a racial classification. Today we think, and we'll discuss this in the next class or two, today we think that what makes something unconstitutional is a racial classification, where the law makes some sort of classification based on race. Well, people of this color get this treatment, people of this color get that treatment. This was not the doctrine by the Plessy court. The doctrine of the Plessy court stated simply that the law must be applied equally. Or more precisely, the law as written needs to be applied equally. Why do I say as written? Because as cogently explained before, this law wasn't always fairly applied. It's very unlikely that they would have arrested a white person who went to the black car. Right? This law was only meant to be applied in one way. So even if on its face, the law said separate but equal, it's fine. In reality, this was a law meant to target only one race. Everyone with me so far? Questions on this so far? The separate but equal doctrine, what we need to get is not just having a black car and a white car. It said as long as the laws applied equally, it didn't matter if there were racial classifications. That was the essence of the doctrine. Okay? Elliot, in the majority's mind, did the 14th Amendment seek to abolish all racial classifications and all distinctions based on color? Why not?
I think that they understood that you kind of had to categorize by race, but
What do you mean you had to categorize the race? What does that mean?
not entirely sure.
Well, I'm glad you said that. What do you think it means? What does it mean a state has to categorize by race? What are they getting at there? It's a bizarre idea. Amanda, why, and this is a really important part, Amanda, why does the state of Louisiana need to consider race in this fashion? What's the argument by the court? It's a bizarre argument, but the court makes it very clearly. Why does Louisiana need to do this? Alana?
Well, they said they didn't want to play it black and white.
Okay, but why would Louisiana have an interest in doing this?
They didn't want black in their property.
No, Gabriel?
Does it have to do with, I guess, the customs?
Yes. So this is the perverse part of the decision. So follow me very clearly. The court basically says Louisiana needs to do this to promote public safety. Let's say this again. It's a jarring thought for sure. But the court says Louisiana needs to do this for public safety. Why? To protect the African Americans. Whoa, what do you mean protect them? Well, they don't say this so clearly, but what the subtext is that if a black person tried to go into the white car, they would get beat up and the state wouldn't protect them. This was viewed as actually, and I'm not explaining this was actually what happened, but the court says this is the way of Louisiana for promoting public order and safety by keeping people apart. And this is actually a very commonly used justification to rationalize segregation, that this was actually for the protection of the African Americans, not for the whites, but to protect them. By keeping them separate, it was keeping them safe. Now, we can laugh at that and ridicule that, and rightfully so. But this is how the court thought. Yes, ma'am.
Well, I think it's a good justification, but isn't it kind of true? Like, if a bunch of, they say like legislative power can't change like how like society feels about something that's going on. Like, isn't it kind of true that someone might get beat up like if they go into the white car, like and the white people don't want them there?
That was my very next point. So I'm glad you raised that. The court says very clearly that no act of government can change how people think. That no constitutional amendment, no judicial decision can eradicate racism. That the 14th Amendment was not meant to eliminate differences between people. Renee, what do you think about that? How do we react to this idea that the law can't change opinions towards race?
I mean, I don't think that it can, but the change has to start somewhere. So why wouldn't it start?
But to Stephanie's point, what happens? The law says, okay, great, tomorrow we desegregate all the train cars, and then any person who goes into a train car is lynched and killed. What's the law going to do there? Let me ask this question to Jennifer in a different way. Jennifer, what do you think would have happened if the Supreme Court held that separate was not okay? Do You think the southern states would have complied?
No.
Why not?
That's just the way it is.
And this is the point where I think I stressed at the beginning of class. I want you to understand these decisions in the time they were rendered. These were very, very dark, dark times. Had the court held that Louisiana's law was unconstitutional, you think that the southern states would have listened? I discussed this the first week of class. On the 1960s, when the Supreme Court said, desegregate your schools, you had a governor of the Arkansas standing in the courthouse, the doors of the schoolhouse, blocking entrance, right? If you read the opinion closely, you sense some frustration. They're basically saying, listen, this is probably a bad idea, but what are we going to do? We're stuck here. We're judges, right? So they tried to do what Taney did. They said, all right, you know what? To prevent strife, to prevent fighting, we're going to simply read the 14th Amendment in a way that justifies this, and at least give them different cars that are equal, accommodations, fine. But they were trying to find a way to justify this treatment, because I think they recognize they could not order Louisiana to do otherwise. Because we'll see in the 20th century, those proactive civil disobedience where governors were setting the schoolhouse doors, blocking access to children trying to learn. Okay? And in fact, the court, in upholding this law, says, oh, but by the way, we have segregated schools. Even in the District of Columbia, which is under federal control, at the time the 14th Amendment was ratified, the D.C. schools were segregated. They argue. How can it be that if D.C. schools are segregated under the control of Congress, that the 14th Amendment requires equality? We'll come back to that point next class. We do Brown versus Board of Education, but I want you to put that in the back of your head for now, because that was a very commonly made argument. So in the end, they said, listen, this is police power, right? So long as this is reasonable, we're not going to get in the way. At the end, they say integration must be voluntary, not forced. Social prejudice cannot be, quote, overcome by legislation. They say if the two races are to meet for equality, it must be the result of natural affinities. Quote, legislation cannot eradicate racial instincts. This is the money quote, right? If one race is socially inferior, the Constitution cannot put them on the same plane. So this is language which evokes Dred Scott. As I told you, even though Dred Scott was nullified by the 14th Amendment, the notion of an inferior race continued. It's right there. You can read it. It's a tough one to teach, because at least Dred Scott was before the Civil War and the 14th Amendment, right? At least Taney was saying, listen, we have this Constitution. But after the 14th Amendment, we had a totally different ballgame, right? We had the 14th Amendment. We had the Due Process Clause. But systematically, the Supreme Court gave up. They gave up on Section 5 of the 14th Amendment. They gave up on privileges or immunities. They gave up on equal protection. In one case after another, they basically wrote out the 14th Amendment. And it wasn't really until the 20th century that this was reversed. So when I say at the beginning of class, forming a more perfect union, I mean that quite literally, because the framers of the 14th Amendment tried to put this into the Constitution, right in there, equal protection, citizenship, right? And you still have the judge who's saying, no, change is hard. And this one was a mess up. So the lone dissent was by my icon, Justice John Marshall Harlan, whom I respect eminently. And again, he was the only dissenter 13 years earlier in the civil rights cases, and he was the only dissenter in Plessy. So, Megan, what did Justice Harlan write in his dissent, which is probably one of the most celebrated dissents in American history? What did Justice Harlan write? Let me ask you this question. That's right, Megan. Harlan says unconstitutional. What does Harlan see as the purpose of the 14th Amendment? Is it merely to ensure that laws are applied equally to different people? What does Harlan say the purpose of the 14th Amendment is? Yes. So Harlan has probably one of the most famous expressions in Supreme Court history where he says that our Constitution is, quote, colorblind. It's a colorblind Constitution. It's a Constitution that knows no race. So it isn't simply the situation that the law must be applied equally, but the law must be applied equally without regard to color. Okay? These were very, very powerful words at the time they were spoken, because Harlan was unfortunately in the minority on this position. He gives a couple examples, right? Why not say that whites walk on one side of the street and blacks walk on the other? Right? Why don't you have some cars for Protestants and some cars for Catholics? Why don't we segregate courtrooms? You ever see To Kill a Mockingbird? So he raises all these examples of why you need to have this principle of colorblindness. Harlan also says it doesn't really matter if the southern states will disregard this. He makes a very different point. He says the Constitution's there. If we enforce it, eventually people will catch up. Okay? He says, listen, I don't pretend that we can eliminate this tomorrow. And he actually, his language is interesting. So let me read this. I want to get his quote right. He says, quote, the white race deems itself to be the dominant race in this country. He didn't say they are. What did he say? He said it deems itself. Okay? And so it is in prestige and achievements in education and wealth. He says this will continue for all time. Okay? If it remains true. Okay? But in the view of the Constitution, quote, in the eye of the law, there is in this country no superior, dominant, ruling class of citizens. This is the money quote, right? Quote, our Constitution is colorblind and neither knows nor tolerates cases among citizens. In respect of civil rights, all citizens are equal before the law. So what's Harlan saying? I'm not an idiot, right? I know that people in Louisiana are going to hate blacks. I know that there's nothing I can do to eradicate that prejudice. But I also know we have this. It's there. And as far as the government's concerned, they cannot make these decisions. I think I mentioned this before, but Harlan taught constitutional law at George Washington University while he was in the court. And I transcribed his lecture notes as part of a project once. And there's this great quote he gives, which I want to read to you. He says, this is around 1898 or so, quote, if there is a black man who can get ahead of me, I will help him along and rejoice. And his progress in life does not excite my envy. And I am glad to feel and know that it is the desire of the white people in this country that the race shall push themselves forward in this race of life. He's like, listen, let them get ahead. I will be happy with this. Harlan compares the judgment of this court to Dred Scott by reaching much further than they needed to. By rewriting the 14th Amendment and basically reading out equal protection, the court continues to gut the victories of the Civil War. And Harlan's no fool. He's like, listen, you may think that this will preserve racial order. The exact opposite. By training an entire generation of people to see that you have separate classes, you are instilling and perpetuating this prejudice. He writes, this opinion will stimulate aggressions, more of the same, and encourage belief that by state law, you have separate classes. In other words, if you grow up on segregated train cars, that's how you're going to think. That's how you're going to view life. And Harlan makes this point very clearly, that even your efforts to try to prevent racial prejudice, you're instilling it and making it deep. Okay. Now, there's one part of Harlan's dissent which I'm sure you were jarring at. You're like, yeah, go Harlan, go, right? And then it gets to the Chinese people, right? So I need to provide some background because I've done a lot of research on this aspect. So Harlan had a very how do I put this? He viewed people of African descent and people of Chinese descent very differently. Okay, and what do I mean by that? He wrote elsewhere that Chinese people cannot assimilate. Okay, while blacks can assimilate and become Americans, he views Chinese people as loyal to the Emperor of China, and they cannot become full Americans. He actually wrote in a couple of cases called Yik Wo v. Hopkins and others about this. But he writes, quote, "There is a race so different from ours that we do not permit those belonging to become citizens. I allude to the Chinese race." Okay. I can't defend him here. I've written about this. I think he was way off base. But in his own heart of hearts, he actually believed that Chinese people and people of African descent were different. So Harlan loses my vote there. But he continues by saying, this thin disguise of equal accommodation for the law is not going to mislead anyone, right? No one actually thinks it's separate but equal. Everyone gets what's going on. These are separate treatments. And in the end, Harlan's dissent proved prescient. It was Harlan's dissent that people for generations cited. And ultimately, when we're leading up to Brown and other cases, we'll say next week, Harlan's view was vindicated. The idea of a colorblind constitution was adopted. Okay, so in the next class, today was a sad class, right? Thursday will be the happier class, if you will, right? So the next class, I want to discuss how this doctrine veered back towards the 14th Amendment. And we'll discuss the desegregation cases and how Brown versus Board of Education effectively reversed Plessy. Are there any questions? All right, thank you all very much. A very enjoyable class. Appreciate it.